Honestly, this is a tribunal of conscience more than anything else, as Article 1 states quite clearly. And so, while we are governed by technical rules, by some technical rules, I think above all, our function as a tribunal, as a tribunal of conscience, I think should be the overriding consideration as is stipulated. I think this is something that is quite important to bear in mind. And we are entitled to draw our own framework for making decisions with regard to this case. As I said in my opening, this is a very extraordinary case because it deals with what Winston Churchill called genocide, the crime without a name. And a few years later, this term, genocide, was coined by Raphael Lemkin, who's a Jew, in his 1944 work, Axis Rule in Occupied Europe, and it was prompted by the methodical extermination of the Jews by Nazi Germany. Then within just a little, so it was introduced, this term was introduced for the first time by Raphael Lemkin. And within a little more than a year after that Nazi episode and its introduction into the English language, this term was used in the indictment of the International Military Tribunal, that's the Nuremberg Tribunal. And within 2 years after the International Military Tribunal pronounced its judgment against the principal German accused, Nazi accused, the UN Assembly then passed a resolution, 96-1, and unanimously declared that genocide is a crime against the law of nations. And to read in part, genocide is a denial of the right of existence of entire human groups, as homicide is the denial of the right to live of individual human beings. Such denial shocks the conscience of mankind. And in 1948, the United Nations General Assembly, in December of 1948, adopted unanimously this convention, which we call the convention, the Genocide Convention. It's called Convention on the Prevention and Punishment of the Crime of Genocide, and it came into force in January 1951. And the International Court of Justice in 51 itself, at the request of the United Nations General Assembly, gave an advisory opinion on the question of reservations to that convention. Now that's very important, because whenever a treaty is enacted, then some states will make reservation and say, oh, I'm not going to be bound by this is my interpretation, this is my understanding. So on the question of reservations, this ICJ opinion established that, and I quote here at my page 2, the principles underlying the convention are principles which are recognized by civilized nations as binding on nations, even without any conventional obligation, and it has a universal character both of the condemnation of genocide and the cooperation required, thereby establishing the universality of its scope. Now all this that I've quoted has in some way or other also been adopted and accepted by one of the first few cases that was brought in Israel itself against Eichmann. They kidnapped Eichmann. The Israeli authorities kidnapped Eichmann, brought them to Israel. They had enacted a law which allowed for retrospectivity, and charged Eichmann. And these are the sentiments that has been expressed by the judges itself as to the position, to locate the position of genocide in the context of a universal crime. Now, judicially, we have the Rwanda case, prosecutor against Kambanda, where it is now considered, and I quote, a crime of crimes. And Shapps, for example, who's written a book called The Law of Genocide, he subtitles his book, The Law of Genocide, Crime of Crimes. So this is it, the mother of all crimes. And this is what we are dealing with. Now, the elements of the crime, of course, are set out in the convention, and as I said, in my opening, made clear, It consists of two parts. One is the actor spheres, that means the act that is involved in carrying out that activity, and the mens rea as well. So genocide, then Article 2 is the key article. It's a very small convention, a couple of pages, couple of provisions. And so genocide means any designated acts, the acts that are designated. And what are the acts? They are set out in Article 2, which says killing members of the group, causing serious bodily harm, deliberately inflicting on the group conditions of life calculated to bring about its physical destruction. So for these three, for killing, bodily harm, and deliberately inflicting conditions of life which are calculated, the outcome must be shown. And it must be shown, the proof of the result must show that the act itself is at least a substantial cause. So these three kinds of acts must be the substantial cause. And if you go back to Article 2, it says genocide means any designated acts committed with intent. So there is an intent. Intent to destroy in whole or in part a national, ethical, racial or religious group as such. Now, the acts are of course punishable, and the whole related to genocide, which is punishable, acts shall be punishable. Article 3, genocide itself, conspiracy to commit genocide, direct and public incitement to commit genocide, attempt to commit genocide, and complicity in genocide. So, the whole range of possible permutations of genocide and its related activities are covered comprehensively. And of course, in who are the persons punishable, they talk about rulers, public officials, and private individuals, but as case law has shown, and as we have elaborated in our written submission, and as has been ruled by this court, the obligation extends to state responsibility as well in our respectful submission. I will not elaborate on that, and I will go straight to page 4, questions for determination by the tribunal. Now, this is what we have set out in our opening statement, that we must show whether the acts occurred, and it is our respectful submission, and I will follow up with the details in a while, that we have shown that the acts occurred, and these acts, secondly, if established, as we say, they have been, fall clearly within the purview of Article 2 of the Genocide Convention, and of course the related provisions in the Kuala Lumpur War Crimes Charter. Now, of course, as is common ground, there must be consistent and persuasive evidence to show a pattern of the alleged acts, which would constitute evidence of dolus specialis, specific intent on the part of the respondent. And here, I pause to say that you must show beyond reasonable doubt there is a specific intent. There is, in our respectful submission, no question of a threshold, and a threshold plus for dolus specialis, for specific intent. In other words, you must show beyond reasonable doubt there was a specific intent as far as genocide is concerned. Now, the point that I make at my page 5 at the top is you do not have to examine every single incident, nor is it necessary to list out in an exhaustive manner all the allegations that are being relied upon. It is sufficient to examine those facts that will illuminate, that will, the question of intent, that will illustrate the claim that we are making. And in our contention, it will show a pattern of acts, and that's what we are required to do, such that it leads to the inference. So from all of this, the inference we draw is very clearly that there is this specific intent to commit genocide. And I cite the Bosnia case, the paragraph is set out, and the bundle is set out as well. I will not trouble to refer to the bundle, the reference is very clearly set out. And here we say the prosecution has provided evidence of facts which, examined as a whole, show that the perpetrators acting in the service and at the behest of the accused, and I'm dealing with charge number 4 only, of the State of Israel committed acts with intent to kill, cause serious bodily harm, and deliberately inflict conditions of life calculated to bring about physical destruction of the Palestinians as a whole or as a part, but directed very clearly to Palestinians. And so the group, when we talk about the group, that must be members of the group. So are Palestinians the members of a group? Some say no. Palestinians, they are just part of, there is some narrative that suggests that, they're just Arabs, they can therefore move into any other part of Jordan and Syria, and they'll be assimilated there because there is no such thing as Palestinians. But now, of course, it is accepted that Palestinians form a distinct group, although they are dispersed and spread West Bank, Gaza, all the other neighboring countries, and the whole diaspora. In fact, it is considered the largest refugee diaspora in the world. And I have given this is a quote from William Cook from his book, Applied to Palestinians. And of course, now it's very clear that Palestinians are considered a distinct group by itself because the United Nations General Assembly resolution just last year, November, almost a year to this date, they gave Palestine status as a non-member observer state in the United Nations. There were, of course, the usual abstentions by Israel, by United States, and its hangers-on, I suppose. Now, we say that we have to place, when we are looking at this charge, we have to place this charge in a historical context. And it is crucial that the allegations against Israel be looked at from this historical perspective. And we have cited the ICJ advisory opinion on the construction of a wall, which has relied on this. In Rwanda also, there was reliance upon locating the problem in the context of history, and as well in the tribunal of the former Yugoslavia, where there was an elaborate discourse on the historical context. And of course, we relied upon the distinguished professor, Professor Ilan Pape, to take us through this historical context. We have for reference his two books. One is, both of which have been tendered. They are exhibits, at P13, and we have also placed in the bundle 2G the relevant extracts from his other book that he has done with another distinguished humanist, Noam Chomsky, called Gaza in Crisis, and we have reference to this at our page 6, right at the top. Now, there are, and these stories are of course augmented by the first-hand accounts of those who experienced the horrors in 1948, as narrated to Dr. Ang, and we had a witness statement, and also Bayan Hout, who we also had evidence through Skype, and she has done a testimonial record of a large number of victims at Sabra Shatila. Now, Palestinian oral history is a significant methodology for constructing the past and the present. So it is oral history that is crucial. The reason why we cited references through Dr. Ang about her account is because it's oral history that explains. So they explain how they arrived at Sabra Shatila from the 1948 episode where they were expelled. And this historical account is important. Of course, it is secondary sources. It's hearsay evidence as well. But as the ICJ Bosnia case made clear, there can be reliance on these kind of materials in international tribunals, more so in an international tribunal of conscience like this. We can rely on reviews, said the Bosnia case, reviews, information from persons, international sources, secondary published sources, interviews, and press reports. Now, the Professor Pape's account, I've set it out in quite some detail here, what he said. But I think basically, if you can sum up what he said, he talked about the period before 1948, before the UN resolution 47, right? And what he said was very clear. There was already a plan in place to take over this particular area. And this plan was going to be activated as soon as the British, which held the mandate of the territory at that time, relinquished that mandate. That was the game plan. And this game plan was put into action. It was put into action when the United Nations announced that they were now providing the Jews with a homeland in a divided Palestine. And this plan, in May 1947 itself, for example, if you look at my page 7, under A, item I, it was in May 1970, the Jewish agency, this was the agency that ran the affairs and that did the consultations. This agency had drawn up a map that designated most of Palestine as a Jewish state, apart from the West Bank of today, which was granted to Transjordan. So this was the plan. There was a plan. And a plan shortly after was devised. It was called Plan D, or Dalet. And this plan was to instruct the Jewish, it was a political and military plan. This Dalet itself was a military plan. Instruct the Jewish forces to cleanse the Palestinian areas falling under their control. And this was done by military forces as well as the main Jewish underground in Palestine at that time called the Haganah. They had several big brigades and they had a huge list of villages that it had to occupy and if necessary to destroy. So from December 1947 till well into the 50s, as our witness Pape narrated, and as is also stated in his book, and I have the references here, this plan was put into action. Villages were surrounded on 3 sides, leaving open space for flight and evacuation at gunpoint. And most of the people did not move. What happened? They were massacred. Their villages were destroyed. We saw how some 530 villages were destroyed. They were razed to the ground. The agricultural land was taken over. Places were cemented over. And this was what Professor Ilan Pape referred to as ethnic cleansing. Now, at that time, the Jewish population was settled or owned because they were buying the land. They were settled or owned on only 6% of the land. The Palestinians were on 94% of the land. And the United Nations devised a partition which granted more than 50% of the land to the Jews, less than 50%. So of course, there was rebellion by the indigenous people who had been living there for hundreds of years. And this intensified that massacre of the Palestinian population. And so at my page 8, at my Roman numerical 9, I state that Plan Dalet itself was genocidal in form. Professor Ilan said, well, it maybe was not at its inception legally genocidal in form, but as it took shape, the ethnic cleansing that then metamorphosed into killings, massacre, and creating impossible conditions of life so that those within Palestine must leave or die. That amounts, in our respectful submission, to satisfy Article 2 of the Genocide Convention. So in 1948 then, half of the indigenous population were driven out, half of their villages, towns destroyed, their urban areas destroyed, and very few ever managed to return. The villages were erased, converted to agricultural lands or new Jewish settlements. And we heard a special committee was formed to Hebraize the names. So the village of Lubia became Lavi, Sauria became Sipori, and so on. The whole idea was to prevent future claims or restore ancient Israel to its, within quotes, ancestral home. Now this plan expressly stated, and I'm quoting now from Bundle 2I, 2I, which is an article which is written by Rashid and Short, called Genocide and Settler Colonialism. This is second last paragraph on my page 8. Can a Lemkin-inspired genocide perspective aid our understanding of the Palestinian situation? It's a very useful article, I found at least, in the International Journal of Human Rights. And they here quote at least 4 different authors, the gist of which points to the fact that Plan Dalet, which expressly was for the destruction of villages to outside the borders of the state. And this, according to Ben Benesti, who is quoted, is a program of premeditated cleansing. Joseph White's, the only solution, he quotes, the only solution is the former head of the Jewish Agency's colonization department is quoted as saying, the only solution is Palestine without Arabs, and there is no other way but to transfer the Arabs from here to the neighboring countries, to transfer all of them. Not one village, not one tribe should be left. So this mold was cast from 1948 and even before. This is the objective, and this is the perspective from which we must understand the activities, the state of Israel's policies. This is the inspiration, the ethos of that state. And so if you look, as we will presently show, then you look at Sabra and Shatila. Sabra and Shatila is outside the borders. So in a sense, they've achieved their purpose. They've chased this large group of people to outside the borders. But then these people were resisting. They were not accepting the fact that they could not go back to their homeland. They were refusing to accept the fact that a place where they lived for hundreds of years should now be a place where they can no longer return, and that they must live as refugees, as a diaspora from that particular place. This was the resistance. There has been talk of freedom fighters, yes. When you are pushed to a corner, any human being, and this is even recognized in UN resolutions, liberation for freedom is recognized. Fighting, armed struggle for liberation is also recognized. Now, so this, in Sabra Shatila, then they had to seek them out. Then they had to kill them. Sometimes themselves, but depending on the situation, sometimes by the use of necessary tools in a manipulation of the geopolitics of that particular country itself. But then people still resist. So they resist, then you occupy the whole territory. So we had a situation where they occupied from a situation where they were granted 56% of the land. Now they have taken over the entire place, and West Bank and Gaza, where Palestinians live in concentrated numbers, are occupied territories. And it is recognized as occupied territories by the ICJ wall decision itself. So there is even a legal pronouncement by ICJ on this point, and to note that Israel participated in those proceedings. unlike this our own tribunal here. So we have a situation where you have, so that is the kind of historical context. I won't go into too much detail on this because we heard the very useful submission of the testimony of Professor Ilan Pape on this. Now, so all I would say is that this ethnic cleansing, all right, if you look at Chomsky and Pape at page, you can just look at bundle 2G, just to try to point home. Bundle G and bundle G. I'll move on first. I think maybe the one. So now there have been in my paragraph at page 9, paragraph 14, paragraph 13. I talk about how the land was seized, and in my opening I've already talked at length about that. I will not dwell on that. And as in paragraph 14, we talk about there were the confirmed massacres. Paragraph 14. Palestinian sources combining Israeli military archives with oral histories list 31 confirmed massacres, beginning with a massacre in Tirat, Haifa on 11 December 1947 and ending with Kirbat Ilin in the Hebron area on 19 January 1949. And there may have been another 6. So these are just some examples that Professor Pape gives in his book Ethnic Cleansing. There's also a very interesting book which shows, which I would like to tender, which is a pictorial. It is From Palestine to Israel, a photographic record of destruction and state formation, 1947 to 1950. It's photographic, and it shows in very clear and rather poignant terms how a whole population was expelled, detained behind barbed wires, in military trucks, massacred, and so on. And the resolution, now it's interesting that in 1948 itself, and this is the basis of some part of the struggle of the Palestinian people, UN Resolution 194 of December 11, 1948, which is in Bundle 2I. Bundle 2I. I think you better not sit down and stand there because you will refer to a lot of books. Bundle 2I. 2I. It looks like 21, but it's 2I.